All right. So good morning, everybody. And I'd like to still say Happy New Year, even though we're still in January and last Tuesday in January, but hopefully everybody is doing well. Today's program is one, and I'd like to thank our friends at NPZ Law because I've gotten to know them really well through the years. They're very involved with our international group. They're experts when it comes to international immigration and nationality law issues, and they help a lot of our members and their clients on these type of issues. And as we all know, we're all reading the news. I mean, when President Trump was inaugurated last week, he's making immigration a centerpiece. But nobody really knows how this is all going to play out and what it means to business and what it means to all of us. So we're fortunate because we booked this event many weeks ago before we knew what was going on. So I am going to introduce David Nachman, who's one of the managing attorneys there, and he's going to introduce his two colleagues, Ludka and Snehal, and then we have a PowerPoint presentation. The way we want to work this is they'll go through some slides and talk about some of the issues that you all care about. And then feel free to enter any questions into the chat box. And then at the end, we could have a dialogue. So with that, David, welcome.
Thanks so much, Tony. And it's always a pleasure to support the greater CIANJ community. And I thank you for the invitation. And I want to especially give a call out and a thank you to Julia and Tareen for helping us to organize, and Kunal on our side, who did a really great job of helping us get everything together. So as Tony said, interestingly, we planned this a long time ago before the disruptions took place. But I'll just quickly introduce our firm, and then we'll talk a little bit about disruptions. So again, my name is David Nachman. I've been doing immigration law for about 35 years now. We're here, our corporate office is located in Ridgewood, New Jersey, and we have offices in Raritan, New Jersey, which Snehal is the managing attorney. We also, like every other business, I think, in the country, we have an office down in Florida, which has dealt up some really interesting challenges in terms of the immigration laws in Florida, because they're different, from state to state. That's really something that's starting to morph right now, is that states are taking hold of this issue. And we also have an office we opened an office up in Toronto. And the reason why we did that is because if all else fails in the US immigration arena, we're sending folks outside the country to Canada, usually to sit there for a little while, and then bringing them back in, which opens the door to other potential opportunities in the US. So we do that as sort of a backdoor way of dealing with immigration. And today, mostly, we thought we were going to talk about the affirmative H-1B arena and what's coming down the pike, which starts in March. And Ludka and Snehal are going to talk about that. But we're also going to talk a little bit about what's called employment eligibility verification and I-9. And that is like a full day seminar. I usually give like a multi-hour seminar on that. And it's as deep as businesses want us to go on that, because it can be extremely deep. There's a lot there, and we'll talk a little bit about that. With that, I'm just going to turn it over to Ludka and have her introduce herself. And I just want to quickly point out, I don't know if anyone was watching, I think it was Channel 7 last night, where Dr. Phil was doing a drive along with ICE to pick up some of the criminals. I never thought that Immigration Customs Enforcement picking up criminals was going to be sensationalized. Like, I don't know if anyone watched, Bad Boys, what they're going to do, so it's really interesting what's happening in this world right now, where they're sensationalizing, going around and picking up individuals. So with that, I'm going to turn it over to Ludka and Snehal so they can introduce themselves. Ludka?
Thank you very much, David. So my name is Ludka Zimovcak. I've been practicing for close to 20 years, most of it with David. And as David mentioned, we concentrate on immigration law purely. We don't do anything else other than immigration. It's quite a lot anyway. I happen to do a lot of family immigration, business type of immigration. I work with students quite a lot on F1s and J1s. Yeah, and I look forward to being here. So if you have any questions, please put them in a chat. We'll try to, take questions as we go. And towards the end, we can just take live questions as well. Snehal?
Thanks, Ludka. Good morning, everybody. Thanks for joining us, and thank you to CIANGA for having us here today. I'm Snehal Batra, one of the partners at NPZ Law Group. I'm at our Raritan, New Jersey office in Somerset County. I've been in practice for 23, 24 years, and most of that time has been also immigration. Like David and Ludka, I also do business and family immigration. I help a lot of international companies expand to the U.S. um, to get, new company L1 visas. So today we have a lot of information for you. We have a short amount of time, so we're going to get started, and hopefully we're able to provide you with some updates on what's going on in the immigration world under the new administration. So
And
thank you again.
before we move on, though, Snehal, I think it's really important for you to mention, I'm going to toot your horn, that you're on the governor's commission and just got back from a tour with the deputy governor in India. So Snehal is on this commission, and maybe just a couple of sentences about what the commission does would be great.
Sure. So Governor Murphy created the New Jersey India Commission in February of 2024. I'm one of the commissioners. We have about 40 commissioners who are, industry experts in law, education, business. The purpose of the commission is to continue to foster relationships between the state of New Jersey and India and help facilitate business growth, expansion. So I was there for about 2 weeks in December. We met with many different organizations such as CIANJ, different industry groups, and really just to help them get to New Jersey specifically and help facilitate anything that they need from us. So it was quite a success and glad to be back.
Awesome. So, Ludka?
Yes. So this is our favorite slide. We're not going to spend, normally we do spend a lot of time when we speak with students or other organizations because it is really important to understand the whole immigration system. But, all we want to say here is that, there are people without status, of course, we know that right now, but there are options for them as well. We're not going to go through every single option for people without status, but it's really case by case. So oftentimes we do speak with companies that will say, I just realized, we have someone undocumented. Is there something we can do? Typically, companies cannot do too much to help them. It's case by case. We need to explore if they have any relatives, are they victims of crime? Can they file asylum? So it's really case by case, but there are options. So, just because somebody's without status, legal status, doesn't mean that they don't have options. Of course, we do see a lot of non-immigrants, so people with work visa, students, visitors. And the idea for us is to figure out more long-term visa options so they can stay here and ultimately switch into green card, permanent residence. And there are several categories as well on the immigrant side. Once they obtain the green card, they can apply for citizenship. They don't have to, but they can after 5 years. If they're married to U.S. citizen, it's after 3 years. So it's an immigration cycle. We see some of our clients for years and years and years because they come to United States, for example, as students. They switch to, for example, H-1B, which is a work visa. Ultimately, they get the green card, then citizenship, then they turn around and file maybe family-based petition for their parents, and so on. So it's a really long immigration cycle. But, the idea for you here is just to understand that, it's important to understand each of these columns. And most importantly, that people, if they lose the status or they came without inspection, that there are options for them.
So we're going to take a deeper dive on each one of these options, but one of the things that's really important, I think, for everyone on the webinar to understand is that this slide is actually a snapshot of the U.S. immigration law system, which runs along a spectrum from the left-hand side all the way over to the right-hand side. And we move with these various categories, we help individuals go from category to category. And that's the strategic planning that a U.S. immigration lawyer does. And so most of the time, these are, again, on the business side, although there might be family-based options that are available to an individual or humanitarian options that are available to an individual. And what we try to do is we try to balance them and also find out whether or not you can pursue those other options without conflicting with their underlying status. So that's usually getting into the heads of an immigration lawyer. That's our thought process on a regular basis.
So whether it's a company or it's an individual, we get a call from them. For example, if it's the organization, we really like this employee to become citizen. That's the call we get. And then we go step by step and we explain how they slowly move through the process, that they cannot just get citizenship, even if, for example, they're married to U.S. citizen.
So what's the normal process, Ludka? Maybe that's the next slide.
Yeah, so I think you were referring to the slide that typically, we see with the companies, what I see the most is a student graduated, they get work permit, they're working for a company, and then company will reach out, depending on, again, what country they are from. We figure out some type of work visa. Typically, it would be the H-1B. Once they get it, it's a dual intent visa, meaning they can stay here more, I don't want to say permanently because it's a non-immigrant and temporary, but they can stay here long term. Then we switch them to the green card once they have that dual intent visa. And of course, once they have a green card after 5 years, they can apply for citizenship. So that's a typical path.
And I'm going to drop a quick footnote in here because lawyers are famous for footnotes. And that is that we work with academic institutions. When you guys have your workshops in the spring for hiring, the students, a lot of times the international students are sort of at a disadvantage because the U.S. employers don't really understand how it works. So what we do is we'll come to those workshops, and we've done so at some of the organizations which I notice are on this program. And we've actually worked with your staff to set up workshops for employers who are interested in hiring your international students so that they can understand how to do that, how to hire those students, and to streamline that process for them.
Yeah. So let's talk about the H-1B because as you, David, mentioned, it's really timely because we are at the end of January and in March we start the H-1B registration. So what is H-1B? H-1B is dual intent visa. It's a non-immigrant visa for professionals in specialty occupation. So when we say professionals, they need to have at least a bachelor's degree or its equivalent. So it doesn't have to be US degree, it could be foreign degree, or it could be a combination of, for example, foreign degree and experience. And, of course, this is not us who would determine that. There are a lot of credentials evaluation companies. Also, the job needs to require at least a bachelor's degree. So it needs to be a professional job. And very important, especially with the latest news, it needs to be related. So whatever the degree is and the field needs to be related to the job. This is really important. So that's very briefly talking about the H-1B. We've had final H-1B rule. Part of it was introduced last year in February, right before the registration, and that had to do with the lottery and registration. So now we do have beneficiary-centric process, which is great because just for illustration, for H-1B lottery, last year we had about 480,000 applicants. The year before, it was close to 800. So this final rule related to beneficiary-centric process was great because there was a lot of fraud with the whole process. What the companies were doing, they were just filing, or what the individuals were doing, they would have 10 different companies filing or doing H-1B registration for them just to increase their odds in an H-1B lottery. So now with the beneficiary-centric system, there could be several entries by different companies, but it's based on the beneficiary. So it will count only as one. So it's definitely fair. The numbers were down, but still, it's a lot of numbers. So that was the first part of the final H-1B rule. And we just got the second part that became effective on January 17th. So there are a lot of changes, and just to mention some. So the specialty occupation that I mentioned before, the definition was revised. I would say it's positive, more relaxed, explaining that several fields are possible, and it happens all the time. Companies do request for the position, they could request, for example, bachelor's degree in chemistry, biology, or life sciences. In the past, USCIS immigration would question it. Now, pretty much the new regulation states that it's okay as long as we can show the nexus to the job duties. So we do have codification of deference policy. What does that mean? We've had it, but now, it's a regulation, so it's great. It means that if someone is filing an H-1B extension and there are no major changes, same parties, same job, that the officer should just defer to prior decision and just approve the case. Unless, of course, there is some material error in the initial H-1B adjudication. Also, they relaxed rules for cap-exempt employers. And this is important because we do not have too many H-1Bs as it is. So we've been in the past few years using these cap-exempt H-1Bs quite a lot. So now with the new rule, the definition of cap-exempt employer is more relaxed, especially about the research component. So in the prior regulation, the company had to primarily, fundamentally focus on research. Now it's just one of their goals. So it's going to be definitely easier to get the cap-exempt H-1B, which is important. Also, and I think this is important because we've never had that in the regulations, is there is some support for those beneficiaries that own companies, even if they have more than 51%, so they own majority. Even though H-1B now, instead of 3 years, they'll get for 18 months with the extension for another 18 months, but it's great. It's a possibility. We have a lot of investors here who are interested and they would like to do the H-1B, but it was always no in the past, and it was difficult to get these cases approved. So now we have regulation regarding the beneficiaries that are owners of the companies. Very important for students, there is extension from October 1st to April 1st. So if the H-1B adjudication takes long time, and right now, prior to this regulation, employers were forced to do premium processing to get decision by October 1st. So now that deadline was extended until April 1st. So if there is no decision until October 1st, cap extension will be extended till April 1st. So it definitely helps our students. And David will talk about it. There is definitely increased site visit compliance. So I think towards the end, David will talk about the different type of site visits as well. There are a lot of other things that happen in the H-1B final rule, but I don't think we have time. Again, it's a full day seminar just for this rule. But, I would say mostly positive changes for the upcoming H-1B. And just to give you some examples in case you're wondering about what does it really mean, the specialty occupation, the typical ones, engineers, chemists, teachers, lawyers, accountants. So it's pretty much the rule is, what does the position require? If the position itself, the occupation requires a minimum of a bachelor's degree in certain specialty, that will be the H-1B. And there are several different ways how we determine. We don't expect our employers to go and check dictionary of occupational titles. We are able, from job description, we are able to determine whether or not this is a professional and specialty occupation. And just to tell you a little bit, because I mentioned we don't have enough H-1B, so not universities, but for your companies that are not cap exempt, they're subject to numerical limitation. We only have 65,000 H-1Bs. We have additional 20,000 H-1Bs for US master's level and higher. I've heard a lot of rumors about we are going to have more H-1Bs or we're going to have less H-1Bs. So far, nothing has happened. But of course, there are changes every single day. But, this hasn't changed for years and years and years. So I did mention the numbers. While it seems really high, it's definitely better than 2 years ago. So we went down from 800,000 to 470,000 of H-1B registrations. So because we don't have enough numbers, there is that lottery. So I remember times before 2009, there was no lottery. We were just applying for H-1Bs, the entire year. So as of, I think, around 2009, there is a lottery. And about 4 years ago, they came up with this H-1B registration system, which is great. Because we don't have to file the full H-1B. Employer just has to register that particular individual, pay $215. It's major increase. Last year it was $10, but we knew it's coming. So right now it's $215 for each beneficiary. So that will take place beginning of March. From beginning of March, typically it runs for about 2 weeks. So it's really important because it's just once a year. For employer to do that H-1B registration. Typically by end of March, we have the results. So the government will announce who was selected, and only those that are selected are able to file.
Hey, Greg, what happened with the
Sorry about that.
Are able to file the H-1B. H-1B needs to be filed starting on April 1st up until June 30th. In the past, we had second lottery, even third lottery, but we never know. Each year, we're just waiting to see what happens. So remember, H-1B starts on October 1st. So that's why I mentioned for those with F1 and OPT, this was critical date for cap extension, but now it has been extending either, until there is a decision or April 1st. But what you have to remember is beginning of March, H-1B registration. So it's right around the corner. So actually right now we are already collecting all the documents and preparing everything for the March, beginning of March deadline. I don't think we have exactly the deadline just yet, but typically it's March 1st. Last year, I think was March 6th. So it just depends, I think, when Saturday falls. Just very generally, H-1B is valid for up to 6 years. So it's 3 years, can be extended for 3 years, other than when the beneficiaries are owners, then it's going to be just 18 months increments. Any time spent outside of the United States can be recaptured. And this is super important. In case the individual is running out of H-1B time, we could do recapture. So we can get that time back. So this is really important. H-1B is employer specific, so it's not like work permit or OPT where, person can work for whatever company. H-1B, once somebody obtains H-1B, they're going to be tied to that employer. However, of course, they can transfer the H-1B to another employer. So once they assume the H-1B, another company can file change of employer petition, not a problem. H-1Bs could be part-time. It's not a problem at all. We get that question all the time. It doesn't have to be full-time. We've done H-1Bs for 5 hours per week. It happens, and it's totally fine. Very important, and especially with the new rule, there is a new rule on H-1B amendments. Any material changes, they have to be reported. H-1B amendment needs to be filed. So for example, if employment location is different now, somebody's moving from New Jersey to California, H-1B amendment needs to be filed. And we are just circling back to the exemptions. So these are very, very important because we don't have enough H-1Bs as it is. So if somebody's working for university, college, these are cap exempt. There is no numerical limitation. They can file H-1Bs at any time during the year, and they can file as many H-1Bs as they need to. But then we have those that are nonprofits, 501c3, that do research, or they're affiliated with universities, colleges. So they are cap exempt organizations. And of course, those that already went through the lottery and they're filing an extension, they're not going to go through the lottery again. But cap exempt organizations are really important. Many of the organizations, what we found is, unless it's a university, nonprofits, they don't know that they are cap exempt organization. So typically with the individual, we try to explore, okay, are they 501c3? Do they do research? And of course, now with the relaxed rule, it may be possible to do the H-1B. The only issue is if somebody has the H-1B with the university or with the nonprofit as a cap exempt organization, if they want to move, I just said that they can easily move to a different company, they would not be able to move to a different organization that normally would be subject to the cap. Because they would have to go through the lottery. So that's the little issue. Unless they keep part-time H-1B with that cap exempt organization. For example, they keep H-1B with the university part-time, then they can get second job with the private industry organization that normally would be subject to the lottery. That's not a problem. But the minute they lose the cap exempt H-1B, it's a problem. They pretty much lose the eligibility.
So if I can just drop a couple of
Sure.
I'm doing a couple of footnotes. I think number one is that, and everyone maybe on this webinar knows that President Trump likes H-1Bs. You may be familiar with the YouTube video where he had met with Silicon Valley leaders and he had talked about H-1Bs. And H-1Bs is the other side of the spectrum. Like I brought up the driving with Dr. Phil and picking up criminals. This is the other side of that. This is the work visas, the highly skilled workers. And I think I speak for Ludka and for Snehal. It's really amazing the resumes that we see on our desks. Sometimes I see 10, 15-page resumes with awards and publications and memberships in professional organizations. These are highly, highly skilled workers. And I just want to call everyone's attention. There was a great article that came out. It was in the New Jersey Business Magazine. It's called The Need for H-1B Workers. It came out on January 3rd. It's accessible online. And in that, actually, I discussed that, the worldwide brain drain begins in the state of New Jersey. We have such rich research in the areas of IT and pharma. Yeah, okay, Silicon Valley is a rival, but the state of New Jersey is really, this is where the seeds for the worldwide brain drain begin. And that's what the H-1B is all about. And the things that you've heard about the H-1Bs displacing US workers, well, that's the media. And the media obviously is going to go after anything that could potentially be pro-immigration. And so, especially in this climate, and the labor condition application, which is what this slide is about, has to do with the fact that you have to do a posting and you have to demonstrate that the individual is not being paid less than a similarly situated US worker. So these are disclosures that an employer needs to make. You have to post the LCA in 2 conspicuous locations for 10 business days and make certain disclosures. And this is what protects US workers against H-1Bs displacing them.
Do you mind if I just jump in again?
please
I want to
feel free.
remind everybody if you have a question, put it in the chat box. But one question that I have is, why do they limit the number? Why not issue more?
Yeah, it's a great question. So actually what happened is back in I'll tell you sort of the history is back, and I'm gonna do it real quick, is in 1990, they proposed changes to the immigration law. It was called IMAC 90. And what happened there was that because of the lobbies, the business lobbies, believing that H-1Bs were displacing US workers, what they did was they cut back on the number of H-1Bs. And that's where we first saw in IMAC 90 is where and it came out in 1991. That's where we first saw the limitations of the 65,000. And then what they did was, obviously, all bills are very balanced. So what they did was by placing the cap on the H-1Bs, they then gave us new classifications for non-immigrants, which were the O, the P, the Q, and the R visas, which don't have caps on them. So if you fall into the O, the P, the Q, or the R, you can do those year round. But unfortunately, the H-1B, because of the lobby, and this, by the way, the labor condition application only came into the law in 1991 under Act 90. And so again, to protect US workers, because the lobbies were so heavy to say that the H-1B, which when I first started doing H-1Bs, Tony, there was no cap. We were just doing H-1B, which was tremendous because for the pharmaceutical industry, which is where a lot of those H-1Bs end up, we were able to create laboratories and people were coming over and manufacturing, and so it was great for the economy. And I'm not sure if you're getting in this direction, but I think, yeah, lift the cap, get rid of it, let the free market guide how we hire these. If it's all about the worldwide brain drain, then we
Right.
should get these people. Why are
Right.
we putting
Yep.
a cap on it, right?
No, I agree. Okay, that's
All right,
interesting. Okay, thanks.
I'm off my soapbox.
Yeah, no. Thanks, David.
Ask great question about, is this based on cap on country of origin? So no, it's not. I mean, and also the lottery, it's really random. It's your luck. The only better chance you may have if the applicant has US master's degree or higher. But with that being said, I have PhD graduates that didn't make it for 3 years in a row. So it's pure luck. But then I have somebody with bachelor's degree that made it in a lottery the first year. But believe it or not, it's totally random. It doesn't matter if you're in cancer research, doesn't matter, pure luck.
Okay, so I'm gonna talk. Can you, Ludka, please go back to the previous slide?
Sure.
Thank you. So I'm going to talk about the labor condition application, as David started to mention what that is. So the H-1B program requires the employer to file this labor condition application that establishes the conditions of employment. This is where the employer specifies the employment information, the rate of pay, work location, the occupational classification. The LCA is also an enforcement system, right? So it basically determines whether or not the employer, as David mentioned, is displacing US workers. And these attestations in the labor condition application, they're basically promises. The employer promises that it's going to pay this H-1B worker the higher of what the prevailing wages as defined by the Department of Labor, or their actual wage for the position. So for example, if the employer pays $75,000 for, let's say, a software engineer, and the prevailing wage, as determined by the Department of Labor, says that the prevailing wage is $78,000 for this position in this area of employment, then the employer has to pay the higher amount, which is $78,000. So that's how this whole prevailing wage versus actual wage comes into play. Excuse me. The employer also has to attest that it's going to provide working conditions that are not going to adversely affect other similarly situated U.S. workers. Also, that the H-1B worker is not going to be placed at a work site where there's any strikes or lockouts. The employer also has to do a posting of the LCA to conspicuous locations for 10 business days. And also the employer has to provide the H-1B employee a copy of that certified LCA before the H-1B worker starts employment. Okay. Next slide, please. Thank you. So there are some obligations for the H-1B employer. The prevailing wage, as I mentioned, has to be paid to the beneficiary, the H-1B worker. They have to have this posting requirement of the LCA. Again, it's to give notice to the non-foreign workers, the U.S. workers, that the employer is employing this foreign national in this position and what the salary is. The H-1B employer also has to maintain a public access file. And I'll talk a little bit more about what that is. But PAF, P-A-F, public access file, that has to be made available for inspection within 1 day, I'm sorry, 1 day after that LCA is filed with the Department of Labor. The employer also has to pay the return transportation to the H-1B employee if they terminate the employment. So typically, the H-1B approval is initially for 3 years, and it is employment at will. So either employer or employee can end that relationship. But if the employer terminates the individual, then they have to pay that return transportation back home. In most cases, the foreign national is going to want to continue to work in the US. So what they do is they end up transferring that H-1B, and we do have a 6-day grace period for the H-1B employee that allows them to do that. Another employer obligation is that if there's any type of material change in that H-1B employment, then they have to file an amendment of the H-1B with the Immigration Service. Material change could include a change in work location, if the position goes from part-time to full-time, full-time to part-time, and also if there is a significant change in the job duties. And this amendment requirement is outlined in the Simeo case. And the employer also has an obligation to update the public access file if there is the material change that I mentioned. This slide pertains to those employers that have that employ H-1B workers, in a majority. So there's a calculation that says, like, if you have more than 25 employee, if you have more than half of your employees are H-1B. So for example, if you have 25 employees and 8 or more or are H-1B employees, and you have additional attestations for the LCA. You have to perhaps do additional recruitment posting, a particular wage requirement. So these are for H-1B dependent employers or willful violators. If the Department of Labor has found that you violated previously an LCA requirement. So when we have a client where they employ many foreign nationals on H-1Bs, and we really need to go into this deeper. Public access file. So the employer has to maintain this public access file for each H-1B employee. This is not a part of their HR file, and you shouldn't keep these documents in the employee HR file, because in the event there is an audit, now the Department of Labor or Immigration is going to have access to all of these records for the foreign national. So it should be a separate file that you maintain for each of your individual H-1B employee. So basically, what does that entail? It entails having the originally signed certified LCA in the file. You also have to have a memo describing how you calculated the wage that you're paying to the foreign national. You also have to have a memo on what type of benefits you're offering the individual. If there's, again, any change in ownership, corporate restructuring, job location, these things need to be updated in the PAF. In fact, if you file an amendment to the H-1B, you're going to actually do a new PAF for the individual. So these are some of the specific documents for the PAF. What we like to do when we represent employers is that we prepare a complete PAF for our clients, so they have it for each employee, because in the event of an audit, the expectation is that you have this already available, because if you don't, this is non-compliance with this H-1B program, which could result in, monetary fines, and depending on the violation, it could be excessive. You are also under the obligation to update that. And as I mentioned, that some of the things that require is if there is a corporate restructuring, change in the position, if you terminate the employee, all of this needs to be updated in the path. Next slide, please. Okay, so if you don't get selected in the lottery, H-1B lottery, as we talked about, we have some other options. So I'm going to leave it to David and Ludka just to go over quickly some of the options, and then we can go on to the fraud investigations, I-9 compliance that David is going to cover, because I know we are already short on time.
That's okay. Oh, Ludka, you're
on
muted.
mute.
Yeah, there you go.
Just noticed.
Yeah.
So
Whenever we do the dog and pony show, I'm always the dog. We have to switch that out, ladies. Yeah, well, we'll get to the employment eligibility verification. No worries. Ludka, so if people, and Snehal, thank you for teeing that up for us. So Ludka, if people don't get the H-1B, like, are there workaround options? And obviously you covered some of them, which are super important, and that is the CAP workarounds, right? With academic institution, government research organizations. So that's one way to go. Obviously, that goes into our thought process sometimes before we actually get to the H-1B registration. We try to figure out, is it better to just do one of those caps, the cap workarounds. But let's say an individual doesn't win the lottery, then what do we do? What
well,
are
either
some of the
they
options?
don't win, or even before we get to the point, as you mentioned, we call it H-1B alternative, but maybe we don't even do the H-1B. You did speak about people that are highly skilled. So, if we have a researcher that has PhD, has publications, I don't think we would even bother with the H-1B, depending on the time of the year. For example, I thought of O1 right away, extraordinary ability, because there is no cap for any of these other than U visa, which is a visa for victims of crimes. There is no numerical limitation. So you can apply for any of these at any time. And these are just some visas, because obviously there is the full alphabet, A, B, C, D. We have all kinds of visas. But again, since we're talking about highly skilled professionals, O1A is for somebody who is, with extraordinary ability. If we see resume that is very artistic and somebody is really, good in arts, any type of field, it would be O1B. If we have somebody interested in investing, it would be e-visa that we would be looking for, assuming that they are from the country that there is a treaty. So it just depends on a lot of different things. First of all, we are going to be reviewing resume, seeing what countries are they from, do they have any additional passport? You, David, mentioned Canada. So if they're from India, but they were born in India, but then they have Canadian passport, that will open up options. For example, E2, TN, it's only for Mexicans and Canadians. We do have, if we have religious worker, it would be R visa. So we have all kinds of alternatives. We don't have time to go over it, but it's important to remember that it's not just the H-1B. There are other visas, and sometimes they are better. So especially if we have, somebody who's just interested in opening up their own firm, and they are not interested in green card, e-visa may be the best. So it's case by case. It's important to do full analysis and just decide what option would be the best.
And Ludka, since we have academic institutions on the webinar, I think it's really important for us to point out that we encourage students to go back for advanced degrees, because that opens the door, because their chances of getting an H-1B if they have a master's degree are better, a US master's degree are better than if they have a bachelor's degree. So we encourage them to go into master's programs, and also, if they have studied in a science, technology, engineering, or mathematics major, then what that does is it opens the door to another 2-year extension that they can get off their normal OPT, which is quite valuable, because what that does is it allows them then to do more H-1B cycles, right? So if they do more H-1B cycles, that increases the probability that they might be able to get that very valuable dual intent visa, right?
And of course, I've been already just mentioned it, since you mentioned educational institutions, I'm getting already emails from schools asking, we've heard that the OPT will be eliminated. So I think this is the right time to say that. Please be sure that you check your resources. We have so many changes going on with immigration. And of course, with that, we have a lot of rumors as well. So you definitely do not want to scare your students, employees, and whatever. So just check your resources, where you're getting the information. There are a lot of bad information. So I did put a link for the newsletter that, you can definitely sign up. We provide all the latest news, even though I have to say, I'm sure by now, just, not looking at the email, there are 3 other changes. So every day there's something new, but just be careful because there is a lot of bad information.
And I think I just want to highlight that many of these, and Ludka, you had said it, but I think it was a little subtle, is that many of these options are treaty-based, and our being involved in the international section of the CIANJ has been quite valuable because we've made a nice relationship, for example, with the Mexican professional organization, and they're open to TNs. So we get TNs both from Canada and also from Mexico. Those are professional visas. So this is something also that I just want to highlight for any recruiters who might be on this call or on this webinar, is that, where you recruit makes a difference, because there are more doors that are open from certain countries than there would be from others. So strategically planning where to do recruitment might also be helpful for you.
David.
Oh, it's my turn. Okay, so with the amount of time that's left, I'm going to just quickly cover a couple of things. This probably is an area that actually Ludka covered it very briefly on one of her slides, which is site visits for H1s. And basically what happened under the H1B modernization rule is that what they're saying is there is going to be an increase in a step up in enforcement. We are going to see that. And I think that one of the things that was sort of dramatic in those changes is also that if the site visits used to be voluntary, but now they're not voluntary. What it actually is that it's going to be mandatory. They've cited what the rules are with regard to the jurisdiction that these FDNS officers have. And if the FDNS officers are unable to make their findings, they can actually deny the H-1B. So that's one pretty dramatic change, actually. But the FDNS is a subdivision within the U.S. Department of Homeland Security, USCIS, and these are folks who are out there to look specifically as to whether or not the employees who are placed on site, as Snehal had pointed out, both in the H-1B arena and the L-1 arena, and also in the R-1 arenas, where the site visits are done prior to the applications, just to make sure that the people who are being placed are actually doing what they're supposed to be doing. So that's one area of investigation. The FDNS, when they do these site visits, this is a list on this slide of what exactly they're able to do. I think that the most important thing, I'm just going to give you the quick takeaway on this, and I think that this is the 20,000-foot view for all HR managers who might be or professionals who might be on this call. It's really important, I think, to designate someone in your organization, maybe it's the receptionist, who let them know where these investigations could come from. So I'm just going to tick off a few of these investigations. Number one is, obviously, you're reading about this, Immigration Customs Enforcement. They can come knocking on the door. Immigration Customs Enforcement, again, subdivision within the U.S. Department of Homeland Security. If they're knocking on the door, chances are they're knocking with a look to the I-9 forms. The I-9 forms are the employment eligibility verification documents that all employers are required to do for all employees after November 7th of 1986, okay? So if you don't have your I-9 house in order, it's a really good time to do this. feel free to reach out for us. We have some really great resources, and also we're more than happy to train your staff. We already covered FDNS. FDNS, basically, they're looking at H-1Bs and whether or not they're, the H-1Bs are doing what they're supposed to be doing. We also potentially have the Department of Labor. Thank you for going to that slide. I'm really bad at doing these PowerPoints, so I just kind of do this stuff from right off the top of my head. So Department of Labor, they're looking at, like Snehal was talking about, they're looking to see, did you do a public access file, which is mandatory after you file the LCA, you're required the next day to have a public access file on your premises. If you're doing H-1Bs, our office prepares the public access file because we know you guys as HR, you're busy, you have other things to do. So we put those public access files together and we give them to you so you can maintain them on your premises just in case Department of Labor comes a knocking. But Department of Labor might come a knocking because let's say there's an aggrieved individual who says they weren't properly paid the federally mandated prevailing wage, or let's say they said that an employer just hasn't paid them what they were supposed to pay them. So then you get into a Department of Labor investigation. Snehal and I have worked on multiple Department of Labor investigations where individuals have said that they have not been paid the federally mandated prevailing wages. And we've dealt with the U.S. Department of Labor directly. Now, what we found under the Biden administration, which was kind of interesting, was the Department of Justice got involved in enforcement. And that was through the IER, the Immigrant Employee Rights Organization, again, a subdivision within the U.S. Department of Justice. And what they'll do is they'll issue you a document which basically asks you all kinds of information about how recruitment is taking place, and just to make sure that there's no discrimination on the basis of citizenship and nationality, which is a potential actionable, that is actionable by that division within the government. We also find that the SSA is involved in now, SSA, Social Security Administration, is not an enforcement agency, but what we did see in the past, and it was very confusing to individuals, is that they issued what are called mismatch letters. So mismatch letters were sent to the employer saying that there was a mismatch in the Social Security number of the individual and when they filed their taxes. So it's interesting to see whether or not we're going to see Social Security mismatch letters in the future or not, but that's where Social Security gets involved. So I think what's really interesting, again, from a 20,000-foot view, is that each one of these agencies has a hand in the employment eligibility verification arena, but a lot of times the regulations for each of these administrative agencies, they're not always the same. They're not all coincidental. So there's a lot of conflict. And this conflict is what causes the tremendous confusion that we find in HR about, enforcement and how this stuff works. So so that is, again, more the 20,000-foot view. And if any of you are interested, our office, as Ludka pointed out, we have a lot of content. We're more than happy to share it with you. There is what I consider to be the Bible on the I-9 rules, which is called an M274. That is not a government secret. It's available on the USCIS website. We encourage you to take a look at that because probably that document itself will answer about 90% of your questions. So I don't want to belabor the I-9 process, but what I do want to do is just quickly point out that there is a new I-9 form. It came down in August of 2023. By this time, everyone, I hope, is using the new I-9 form. The expiration date, this is the heading from the new I-9 form. So that is when it began, again, August 1st of 2023. It's kind of nice because what happened was they decided to consolidate the I-9 form. It became kind of onerous. It was like a 3-page document. It's now a 1-page document. There is a supplement A, which is used for preparers and translators. And they also now have a supplement B for re-verification. I personally like the way that they did it. It is onerous to do, but and so there are a couple of other changes. There's a highlight about the anti-discrimination rules, and you can see that sort of right on your on the slide there. And in addition to the supplement A and supplement B being separate, there also is a little box that you check where the employer is allowed to say that they're using the alternate verification methodology. And the alternate verification methodology came down and allows employers to verify I-9s remotely. Now, I'm not a big fan of the remote methodology. So there are a couple of different ways that the I-9 can be done. Everyone probably knows. Number one, you can see the person and review the documents in person. That's number one. That's one way to do it. The second way to do it is the company can deputize a person, and it can be a family member who looks over the documents and then signs on behalf of the company. But even if you delegate or deputize someone, the company is still responsible for errors. And so, but generally that's pretty reliable. And the third methodology is this remote verification. And the remote verification, it's called a alternate virtual verification. Thank you, Ludka. And so this is a step-by-step methodology that you can use, and you have to tick the box on the I-9 form. But basically what it requires is step-by-step. This slide explains to you exactly how it's done. And so we've received a lot of questions about, how this shakes out. And again, because E-Verify, which is a process some of you might be using, it's not mandatory in the state of New Jersey unless you're a government contractor, but the E-Verify process is what I refer to as the I-9 process on steroids. And basically what it does is it is a database that will quickly check an individual's verification. So what you'll do is and it doesn't substitute, by the way, for the I-9 form. You have to do the I-9 form and you have to do E-Verify. Now, there's also a new program that everyone should probably know about, where what the government is doing is shifting the burden from employers to the employees, and that's called NextGen. And if you go actually to YouTube, there's a really nice video that explains what the government has in mind by using the NextGen procedures. I've listened to a lot of interviews with the folks at the enumeration division of the USCIS because I know it's crazy, but I'm actually into this stuff. And I find it fascinating because I've studied the history of the I-9 form from 1986 until now. And I love the dedication of the people in that division because I think that they're really looking to make things easier for employers, and they want the very best, and that is a documented workforce. And so this NextGen, I think, gets at that and, again, shifts the burden away from the employer to the prospective employee. Now, in addition to this E-Verify Plus, we'll go to the next slide, Ludka, is a new pilot program that was also proposed, which is going to be for folks who are not necessarily in the E-Verify program, but it's going to be an application-based program for employers with 500 or less employees. And this will give you the opportunity to do remote verification. But again, it's going to be an application-based process. So this sort of this did not take center stage. Obviously, right now, employers are more concerned right now about getting their I-9 records in order. And so, but I think that we might see that percolate again as the administration, as the time goes with the administration.
David, I have a question for
Yes.
you that I just got from one of my clients. What do you recommend that employers tell their employees to carry? What kind of documents? Should they be carrying originals, original green card, original work?
That's a great question. We've been getting that on
the raids, and we see what's going on with the TV. What do you recommend?
It's a great question. So actually, we had that discussion internally yesterday, and there was discussion about whether, because we've had some clients actually ask us to draft letters on their behalf, explaining, what their status is and what the situation is. We also have people who are carrying receipt notices. I think the receipt notices probably work. If our clients want letters done, and as long as those letters accurately describe what the situation is, I don't think that that's a problem. And I think that that gives them obviously a comfort level. So I don't have a problem preparing a letter like that. But I think that, obviously carrying the documents is going to be tremendously helpful because that's obviously going to protect them. There's also a document that we're giving clients. I think the more the bigger concern is, what do you do with people who are out of status potentially? Okay. And so we do see individuals who are out of status, and we're looking for the day when things change and we're going to be able to make make a filing for them and to get them in status. But we have a Know Your Rights document, which we give them, and it explains basically what their constitutional rights are if, let's say, for example, they either get picked up or or somebody questions their status. So if anyone is interested in receiving that document from us, we're more than happy to send it out, and you can feel free to disseminate it within your organizations. It's just very helpful information, and it's not necessarily for them, but also for other folks in the community that they may be able to give that information out to. How about you, Ludka? What do you tell the clients?
Well, up until now, I was telling clients, do not carry your original green card, because you may lose it, then it's a problem. But right now, it may be safer to carry it, I guess, because we don't know, we don't have any guidance so far, but it's important, to have some type of evidence of whatever status they may have.
Or just copies.
Copies.
Yeah.
Students, it's easy. They can easily check it in CVIS. But, otherwise, it may be complicated if they don't have anything on them. So maybe at least copy in a phone,
I was going to say, put on your phone, maybe it'd be good. Right?
But the problem is that we don't know yet. It's all, we kind of don't know. So slowly we will find out.
So I just want to quickly say, I know, Tony, I know we're running out of time, but I just want to quickly say to everyone, with regard to these so-called raids that we're hearing rumors about, with regard to these stops, with regard to the drive with Dr. Phil, they're going after individuals who have criminal records. They're going after individuals who are public safety concerns, and they're going after individuals, but they are discussing individuals who are collaterally related to those people. So if there are folks who are hanging out with those people that they're going after, they are rounding them up. So that's what seems to be going on. So,
wrong place at the wrong time.
Yeah.
Oh, yeah.
So,
you have a question.
yeah.
Yes, quick question. So would you recommend or not recommend professionals traveling, they have all documentations, H-1Bs and stuff, or maybe OPTs, to attend conferences, international events? What would be your suggestion right now?
So I'm just going to say what I think. And of course, David and Snehal can chime in. It's because it's so uncertain. And these days, and I think the next, coming weeks, there's going to be something new. We are worried there's going to be some type of travel ban or something similar. So it's not the best time. Like right now, today, it's okay. But I don't know what's going to happen tomorrow. So that's the problem, that, we kind of need to be flexible and just see what the situation is going to be. But, remember 4 years ago, we had travel bans right away, and that could still happen. We just don't know what the future will bring. So if people want to be absolutely safe, maybe better not to travel. I mean, they can, but they have to understand the risk. Because what they are saying, they're going to scrutinize everyone more at the port of entry, and obviously if they have to apply for the visa at the US Embassy, we expect delays. It's going to be maybe slower, more vetting. So probably not the best time to travel.
Yeah.
That's my opinion.
Yeah.
If it's not essential, then I would say postpone it until we have some more information.
The crystal ball is very blurry.
Yes, it's not so crystal.
No.
Anyway, David, Ludka, and Snehal, thank you very much. A lot of information packed into today. We should actually talk about maybe doing a follow-up program. Again, I know this is being recorded. I got a couple of emails saying, is this going to be out? Tareen, you could probably send it out to all the attendees. And Julia, we could make this the featured story for Friday's Business Beat. So thank you, Julia, Tareen. Thank you, David, Ludka, Snehal, and everybody for being on. And we'll see you